Good day, everyone. This is Group 15, and today we'll be discussing a very important topic under the law of trust, which is determination of trust. And in this presentation, we'll be breaking down how a trust can be terminated with relevant judicial authorities.
A trust is a relationship which arises whenever a person called the trustee is compelled in equity to hold property, whether real or personal, and whether by legal or equitable title, for the benefit of some persons or the objects permitted by law, in such a way that the real benefits of the property accrues not to the trustee but to the beneficiary or other objects of the trust.
There are different ways a trust can be terminated, and some of these ways include: we have the revocation by the trustee, we have the disclaimer by the trustee, we have retirement or request to be discharged by the court, we have removal of the court, we have fulfillment of the purpose of the trust, we have expiration of time, and then we have the rules in Saunders versus Votia.
Trustee can exercise the power of revocation as provided in the terms of the trust, provided that he reserves the power to revoke.
Another way by which a trust can be terminated is by disclaimer. If a trustee gives notice that he is not interested in being a trustee, in such instance, he must exclude the deed. And this was upheld in the case of Nylander versus Thomas.
Trust can be terminated by performance or fulfillment of that trust. In a situation where a particular trust was created for a defined and specific purpose, at the expiration of that purpose, that trust ceases to exist because such trust has been performed and has been executed. For instance, a trust is created for the sake of a person's education. The trust terminates on the day of the payment of his final school fees or on the day of his graduation.
The rule in Saunders versus Votia, where the testator in his will gave trustee shares on behalf of the beneficiary, expressly stating in the terms of the agreement that at the age of 25, the trustee should hand the shares over to the beneficiary. Upon the beneficiary turning the age of 21, he demanded for the shares. So the rule in Saunders versus Votia ruled in favor of the beneficiary, stating that once he is of full capacity and he is of sus juris, that means he is of full age, the property or the shares can be handed to the beneficiary. So that is one of the ways trusts can be terminated in the rule of Saunders versus Votia.
That a trust be terminated is by retirement or by discharge. A trustee can request to retire or the request for a discharge by the order of court or be discharged by court order if there are certain instances like breach of trust and conflict of interest.
One of the ways of termination of trust is by removal by court. And said the court has an inherent power to remove a trustee with or without a new appointment in his place. And in the case of Adesheye versus Williams, it was held that a court would remove a trustee if it is satisfied that the continuance of the trustee in office will be prejudicial to his performance, that is to his performance on the trust, and also to the it will be against the benefits of the beneficiaries.
Expiration of time is one of the few ways that a trust can be terminated. Now, when a trust is supposed to take place within a time frame, then after the time frame, the trust automatically comes to an end because trust has a specific time, and after that time, the trust has elapsed.